Good morning, and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am located at 1563 Main Street in Peckville, and I'm here every Sunday from 8 to 9 a.m. on these stations to bring you, the landowner, valuable information that you need. You, as the landowner, royalty owner, need regarding natural gas development here in Pennsylvania. So if you're looking for landowner information, then this is the show for you. At the Clark Law Firm, I focus on landowner representation, never have, never will represent oil, gas companies, or the industry side. I represent landowners for many, bottom line is essentially anything related to natural gas development, oil and gas leases, negotiations, reviews, and consultations for leases, amendment modifications, pipeline, water line agreements, royalty deduction issues, estate planning. I keep talking about it, doing more and more estate planning. Just finished up a couple wills this week, and then also working on a couple trusts. Also, unitization issues. Is your property appropriately unitized? There are acres not in the unit that should be. Surface use agreements such as well pad agreements, meter site, compressor stations, valve sites, etc. Anything that's going to be on the surface of the property, roadway agreements. Again, any and everything related to natural gas development here in Pennsylvania. So if you need representation, you want to learn more, you can contact the office directly at 570-307-0702. That's 570-307-0702. And as you'll hear me say on occasion, and I'll say it here now, if you haven't done it, go check out our websites at pagasleaseattorney.com and pipelineattorney.com. Go check it out, whether you need representation or you're looking for information. Good quality information. I think that, I'm a little biased, but I think they're excellent websites for landowners. And if you miss any of, we're at the beginning of the show, but today's show will place, if you have to leave early, it'll be up and available tomorrow, Monday morning, on the websites at pagasleaseattorney.com and pipelineattorney.com, as well as many hours of prior shows that we have archived available on the websites. You may get tired of hearing it if you're a regular listener, but I got to be honest, I'm a little proud of this. And we've been doing the show. I've been doing the show since August of 2010. So it gives you a really good idea what's going on out there and how much there is to talk about. I also talk about, one of the things I work a lot on nowadays is pipeline right-of-way agreements. I'm going to say this. If you enter into a pipeline right-of-way agreement without an attorney who understands these agreements and what can be done to improve these agreements, whether it be for additional compensation, in other words, money, more money, or at the bare minimum, and I stress minimum, better language. Protect yourself from liability issues. That's fundamental. That's bare bones, basic stuff. Protect yourself from future surface operations that you weren't thinking about. Protect yourself from having an electric line ran through this pipeline right away, or what you thought was a pipeline right of way agreement. Protects the value of your property for future generations, or if you would ever want to sell the property. Protect your children from having these permanent right-of-ways that are going, or rights-of-way going across the property. Protection. In every case, I cannot think of a case. I say this, I've negotiated, been involved with pipeline right-of-way agreements with over 50 separate companies across Pennsylvania. Over 50 separate companies across Pennsylvania. And I can't think of one. I cannot think of a single agreement that I was working on that we were not able to make better. And in many cases, significantly better. So do not, and I talked to quite a bit about pipelines last week. And if you missed it, go pagasleaseattorney.com, pipelineattorney.com, and, hey, the name says it, pipelineattorney.com. Go learn about leverage leverage assessment. And one of the things that I've learned over life, and this is a fundamental thing, and I try to preach this to my children. I have a 20-year-old son, and I have an 18-year-old son who's in a senior year of college, senior year of high school, going off to college. And I preach to them all the time about understanding and awareness of what you do not know. It's real simple to say, oh, I know this, I know this, I know this, but to realize and understand what you do not know, that's intelligence, that's wisdom. Understand what you do not know, and then find out, well, how do I learn it? Where can I get this information? Does somebody else know who can assist me? And I assure you, when you're looking at these single pipeline right-of-way agreements, there is so much that you as a landowner, I don't care if you're a lawyer, I don't care who you are, I don't care if you're the smartest person on the planet, if this is the first time that you've ever seen this and you don't understand how this process works, you don't understand the intricacies of assessing leverage, you are going to sign a worse agreement than what you could sign if you understood these things or you had somebody assisting you who had that expertise. It is just very, very important. And I see it happen. I see people sign bad agreements all the time, and they rely on the gas company landman who's out there to what? Get them to sign these documents. They are there to get you to sign. They are not there to offer you advice that you need to know to put yourself in a better position and to get the best possible agreement. Can you imagine if the company is sending out landmen to landowners and telling them, hey, listen, make sure that these landowners get as much money as we can give them, and then also make sure that we give them the strongest agreements that limit our ability to operate in the future? Well, of course they don't say that. That's lunacy. So we need to understand that, here it comes, first section, landman works for the company, not for you. You need to understand that. I am Attorney Doug Clark. You're listening to All Things Marcellus. I'm here every Sunday from 8 to 9 a.m. And just to finish up again, we need to make sure that Pennsylvania landowners are educated, informed, and understand. And again, the show is never for specific legal advice for any individual, but a lot of times, the idea, get you thinking, get you understanding. Hopefully when people hear, wow, 50 different companies, wow, there must be a lot of stuff going on here. There must be a lot of different types of agreements out there. And I only have one. I was only presented with one agreement by one company. Well, you need to understand what can be done. How do you maximize this? And I'll tell you, there's a lot of good things on the internet, and boy, there's a lot of bad things out there too. And if you're just randomly taking advice from internet message boards, in my opinion, I don't even go to them anymore. Well, not that I ever really went to them, but I go and I see them and I want to start pulling my hair out because it just doesn't, there's such bad information out there. People are signing bad agreements because they're relying on misinformation and bad information, and we want to stop that. Again, you're listening to All Things Marcellus, me, Attorney Doug Clark of the Clark Law Firm. And what we're going to talk about today, I'm going to talk about, had a request, I'm going to talk about gas lease amendments, modifications, and also extensions, meaning extending a lease. So what does this mean? And again, I want to stress right now, and I will probably say this a couple times, look, this is never specific advice for any individual. We also want to make sure that, or I do, that I'm offering advice that's going to be helpful to large groups of people who are listening to the show. We don't want to get too bogged down to a small issue only affecting a few people, but I think that we can talk about gas lease amendments, modifications, extensions, ratifications in a way that we can get, I'm going to use some examples locally in northeastern Pennsylvania, but again, a lot of these same concepts, they apply no matter where you are, no matter what company you're dealing with, And the same thing can even apply if a company wants to extend your pipeline agreement. I'm gonna jump on that real quick because I just thought of something. Here's the other thing: things are slowing down. Okay, things are slowing down drastically on the ground due to the price of gas. That's a reality. So what does that mean? Well, that means that if you entered into a pipeline right-of-way agreement, maybe a roadway agreement, or even a gas lease, that because of this slowdown, maybe you entered into a pipeline right-of-way agreement that had a 2-year option, meaning that once you signed, the gas company or pipeline company had 2 years to decide whether they were going to what's called exercise the option, meaning go ahead, pay you the money to install the bigger payment, typically in the back end, to install the pipeline and put it into the ground. And a lot of times these agreements may say you have to, as a pipeline company, start construction within 2 years. However, given the market, lack of drilling, lack of money, capital by these companies, they may want to push that out. They still may want to do the project, but they may want to extend it. So instead of saying, hey, we need to do this within 2 years, hey, landowner, we want to add another couple years onto this. Well, if you are approached to amend, modify, whether it be a pipeline agreement, gas lease, any agreement, you need to speak with somebody, get some consultation with somebody who understands what to do and can give you some good, solid advice. Here's the example with the pipeline right-of-way agreement. You entered an agreement saying 2 years ago, gas land or pipeline company landman comes out, wants you to extend it for another 2 years. Says, hey, we'll give you the same terms. You say, okay, all right, well, might as well go ahead and do this. Maybe you had an attorney even the first time and you thought you had a pretty good agreement. Well, you need to understand that we've just fast forwarded 2 years. And what may have been the market price 2 years ago may not be the market price today. So by the company landman saying, okay, yeah, here we just signed this, we'll use the same agreement, no big deal. Well, the reality is that company may be paying an extra $5 or $10 per foot today that they weren't paying 2 years ago. And that's just one example. Maybe you entered into an agreement 2 years ago where you had a lot of leverage that you could have said no. You could have negotiated more money, but you thought, well, or bottom line, maybe you made a mistake and maybe you didn't consult with an attorney, or maybe your attorney did a bad job. Here you go, 2 years into the future. Well, you know what? You got to check this out because this is very rare, but you may have a second bite of the apple. So you need to take advantage of that. You need to take advantage of it. We don't want you to take a bite into the apple or in the same spot you bit 2 years ago. We're going to find a nice shiny portion of that apple, and we're going to take a big bite there, and we're going to get you a better agreement. And if there's more money to obtain, we're going to do that. If there's better terms to obtain, we're going to do that. But you have to look at your situation. The state is full, the Commonwealth of Pennsylvania is full of people who signed bad agreements, who look back and said, boy, I wish I would have known then what I know now. I have people say to me all the time, boy, Doug, I wish I would have talked to you when I signed my gas lease or before it. I wish I would have talked to you before I signed my pipeline right-of-way agreement. Well, when you have an extension for a gas lease or a pipeline agreement, well, you know what? You have that opportunity again. You have that rare second bite of the apple. Let's take advantage of it. I'm attorney Doug Clark. You're listening to All Things Marcellus. I'm going to talk about lease amendments, ratifications, modifications, and again, extensions right after this break. I'm here every Sunday from 8 to 9 a.m. on these stations. I'll be right back. Welcome back to All Things Marcellus with me, attorney Doug Clark of the Clark Law Firm. And reminder, I represent clients, landowners, royalty right owners with rights in Pennsylvania, all across Pennsylvania, whether it be the western border, southwestern Pennsylvania, anywhere within the Commonwealth of Pennsylvania. You can always give us a call. With today's technology, you've heard me say, rarely, if ever, in fact, virtually never has distance been an issue. Even with the client, I just like saying this word sometimes, even with one of my clients located in Micronesia. And if you don't know where that is, neither did I at the beginning. But yeah, so you understand, I've said this recently, just in the last couple months, actually last month or so, had a client sign the highest per acre bonus of a landowner client that I've ever had since dating back to 2007. So, anywhere in the state, anywhere, you can always reach out to us, 570-307-0702. Okay, so I want to talk about gas lease amendments, modifications, ratifications, and extensions. A lot of big words there. What are we talking about here? Well, we're talking about individuals who have entered into oil and gas leases in the past, and now the company landman knocks on the door, shows up and says, hey, we'd like to extend your existing lease, maybe. We would like to amend or modify the terms of the lease that you've already signed. Now, sometimes that can be a good thing for landowners, and sometimes, and often, if the company wants you to do it, often the reason why the company wants to do it is because it's going to be to their benefit. However, it can be a win-win situation, a win for the company, a win for the landowner, but we need to look at your individual situation, your individual circumstances, and what exactly does your original lease say? What does this amendment and modification say? And ultimately, really breaking down and looking at a bunch of factors to decide, is this right for you? And when I say you, I mean you. I don't mean your neighbor. I don't mean the guy down the road. I don't mean the people at the gas station, at the church, at the funeral home, at the diner. I mean you. We need to look at your situation. So again, this is not specific advice for anyone, but it's an idea to get to get you thinking about various things that you should be thinking about. I'm sitting here in front of me in preparation for the show. I made some notes of some factors that you'd want to consider if you were a landowner facing or being asked to sign an oil and gas lease amendment or modification. And it's not an exhaustive list, meaning that there's more things to consider, but it literally takes up the entire page of my legal pad. So it just gives you an idea of how many things there are out there to consider. And some lease amendments and modifications are pretty simple, are pretty basic. Some are pretty complex. And we need to understand fundamentally is, what does your original lease say, and what are you being asked, what are you being asked to modify or amend? And then what will be the final result in the event that you do agree and you move forward and amend and modify your existing lease. I am Attorney Doug Clark. You're listening to All Things Marcellus. I'm here every Sunday from 8 to 9 on these stations, and we're talking about oil and gas lease amendments, ratifications, and modifications. So, dating back several years ago, many landowners it kind of started with a lot of these original leases, the oil and gas leases, had a maximum unitization size, meaning the largest unit that the company could create, of 640 acres. And that was left in a large part, the reason why that number appeared, nothing magical, it's a square mile. But out west, there's laws, and sometimes companies in certain places are by law that they create these grids, and that's the maximum size of the unit. So when you start using these same lease forms in Pennsylvania, where for these Marcellus wells we do not have this maximum unit size, well, what happened is this company said, hey, our technology allows us to drill these lateral or horizontal wells thousands and thousands of feet in an outward direction. So it is more cost effective, less environmental footprint, and then also for the company side, we can hold more acres if we make larger units. So the problem we have as a company is, our lease agreements say that we can only create units of a maximum size of 640 acres within the unit. So what do? we'd like to make them bigger. Our leases say only this size. They go out. They say, well, let's send a landman out there. Let's go knock on doors and let's request that landowners agree to amend or modify their lease to increase the maximum size of the unit from 640 acres. A lot of times they would double it to be 1,280 acres. And a lot of times it would be unlimited. Or sometimes if they already knew, hey, we're going to create a unit and we'd like it to be 800 acres, they would ask for an amendment and modification to go from 640, say, to 850. They want to make sure that they have enough of an amendment to cover them in the event any unforeseen issues arise in the future. So that was kind of like the basic thing that we saw early on. And for those standard types and pretty standard amendment and modification, companies say, hey, look, we do not want to set the precedent of paying landowners any compensation to increase the maximum size of a unit that is allowed under the oil and gas lease, because we're going to go out there, we're going to ask hundreds, if not 1,000 plus people to change the size of their change the lease term to allow us to create larger production units. Because when they went and knocked on doors, the first thing that every landowner, and as they should say, okay, you want me to agree to something that's going to benefit you, company. What's in it for me? What is my benefit? And of course, your benefit, often you're going to be turning towards compensation or money. So what do? You say, hey, how about you pay me a per acre price to amend or modify? So if I have 100 acres and if you gave me $1,000 per acre, give me $100,000 and I'll agree to that. Well, company said, nah, we're not going to open that door because we got to do this with hundreds, if not thousands of people. So they said no. The other thing that landowners would say would be, I signed at 12.5%. My neighbor signed at 20%. Or they may say, I signed at 15%. My neighbor signed at 18%. So landowners would say, hey, yeah, I'll agree to amend or modify my lease as you're requesting, but instead of 12.5% or 15% royalty, I would like my royalty percent increased. So give me a couple extra percentage points of royalty, and yeah, I'll sign that document. Well, again, companies are saying, no, we're not going to do that because we don't want to make these changes. And once we open that door and word gets out, then everyone's going to have the same type of demands. And overall, this is going to cost us a substantial amount of money, whether it be in per acre payments or in royalty payments. So you didn't see companies agree to make these type of payments. Now, very important, and that's what I'm saying. There's so many intricate details, it's just impossible to to explain in a single show. It would probably take several shows to really try to give this broad-based explanation. But you have to look at your situation, because even landowners who are being asked to sign amendments or modifications to do a simple thing as to increase the size that the company can make these units, well, in certain cases, the landowner actually may have had or did have leverage that they could simply say no, or they could negotiate for a one-time payment or possibly even an increase in royalty percentage. Those circumstances are rare, but you need to identify that, because if you do have one of those circumstances, it could be the difference of hundreds of thousands of dollars, and depending upon your acreage, literally potentially millions of more dollars over time. And that's why I say, if you as a landowner, and most landowners can't identify this because it's complicated and it takes experience in dealing with it day in and day out, you need to identify, do I have that leverage? And for somebody with the experience, they can identify hopefully pretty quickly, and typically pretty quickly, will say, okay, well, no, we don't have that. Here's what your situation is. Here's the assessment of what your leverage is. Here's the good and here's the bad about this amendment. And in your case, you may have a situation where you have a lease that is 18% royalty, but has a unit size limitation of 640 acres. Well, You may think, oh, I have all these cars. I got a great hand that's been dealt to me, and I want more money. I want higher royalty. Company landman says, no, 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 we're not going to do that. We're not going to do that. And you say, company landman, I hear that Doug Clark say works for the company. I don't believe him. Well, here's the thing. Absolutely. There are many, many times, or sometimes we'll say, landmen are telling the truth. Absolutely. And it's our job to know when that is. So you don't want to just, not get any assistance and just take it and say, they're lying, they're always lying. Well, sometimes they may be telling the truth, but we got to identify and say, okay, what is your leverage and what are your options here? And that is a key thing. And very, very often, in most cases, it's going to be extremely difficult, if not impossible, for a landowner to identify what they need to identify in order to assess their leverage. So in most of these cases, absolutely, most of these cases, the landowner was faced with the question of, do we want to agree to increase the size of this unit? Well, and why are we going to do this? And we're not going to get any money for this. We're not going to get a higher royalty percentage. But circling back here, if you had a 15, 18% lease of royalty and you're asked to extend and you think you have this leverage when actually you don't, well, what can happen is if you don't agree, it's possible the company could just simply surrender your lease. Just let your lease expire, surrender it beforehand, and then you say, I had 18%, now I don't even have a lease. They're drilling, because I don't have a lease, I'm not going to be in this unit. I better get back with this company, get a lease, get myself in this unit, and look for future royalties. Well, now you call the company and you say, hey, company, my lease expired, or you released me or surrendered my lease. I'd like to enter into a new lease. And you know what? I know I didn't want to increase my unit size from 640 acres, but I'm willing to go bigger now, and you can have whatever size unit you want. Company says, well, hey, that's good to hear. If you're lucky, and it's probable, but every case is different. They say, well, we're willing to enter into a new lease with you. However, the market has changed. And when you did your first lease at 18% and say $4,000 an acre, well, now what we're offering you is a maximum $500, say, per acre and 15% royalty, and where your old lease either minimized or precluded deductions of post-production costs, we're going to deduct everything in this lease. So now your choice is an inferior lease that's going to generate, if you have gas, much less money. And what happened was, you wrongly assessed your leverage. You miscalculated. And now you're faced with, you've lost your lease at 18%. And look, some companies may say, especially in this market, look, we're not even going to give you $500. We're going to give you $5 an acre, and we're going to give you 12.5 or 15% royalty, and we're going to take full deductions. And if you don't like it, don't sign the lease or sign with another company. Problem being, there are no other companies that want to sign a lease with you. Now you're stuck. So where can you screw it up if you don't understand the situation? Well, you can wrongly assess your leverage and think you have no leverage and just go ahead and sign, when actually maybe there's a well that's drilled underneath your property and you actually have a lot of leverage, and you might have left a lot of money or terms on the table. So you made a mistake by wrongly assessing your leverage and not realizing that you had more leverage than what you thought. And then you got the flip side. Another very big mistake that landowners make is that they believe that they have more leverage than what they do. So they overplay their hand. They end up losing a lease, and now they're stuck out in the cold, and they come back and they say, hey, I want to do a new lease. Maybe the company says, yeah, we don't need you anymore. Thanks, but no thanks. Or they say, okay, we'll do a new lease, but we're going to give you no bonus, and we're going to do it at 12.5%. You don't like it, find someone else, and there is no one else. We got to make sure that we're making informed, intelligent decisions with all available information. I am Attorney Doug Clark. listening to All Things Marcellus. We're going to talk more lease amendment and modification issues after this break. I'm here every Sunday from 8 to 9 a.m. Here again in about 1 minute. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Reminder, you can always contact the office, 570-307-0702, and make sure you check out pagasleaseattorney.com, pipelineattorney.com. We will have today's show up and available tomorrow, and there are many other shows available. Been doing the show since August of 2010. Okay, so going to jump right back in, talking about gas lease amendments and modifications. That last segment was talking about a very basic one, but to give you an idea of the importance of understanding and assessing your leverage and options. Now, another common, we have this evolutionary process of these amendments and modifications. So another common today in certain pockets of northeastern Pennsylvania, especially, we have companies that are approaching landowners and asking to amend and modify leases. And what they're really targeting in a lot of these cases are what we call, or what I call, and others as well, minimum well obligations. What does that mean? Well, you take some of these, what I call super leases, and I think I'm the only one that calls them that. You take these super leases. I'll give examples of the Friendsville lease. There's several of them out there. The Wyoming County Landowner Group lease. There's an Auburn group. There's a bunch of them out there. So anyway, you take these leases, and one of the very attractive qualities that the Friendsville lease, Wyoming County Landowner Group lease, and others have is that there's a minimum well obligation that the company faces, meaning that, and sometimes it's hard to understand this, and it's hard to understand it when you look at these leases because it doesn't just often typically say, well, you must drill 4 wells in 5 years, or you must drill 4 wells in 10 years. What you got to look at, because sometimes there's formulas in these leases. They can be very complicated, these larger leases. But the point is that these leases essentially have a requirement that the company must drill multiple wells in a certain time frame in order to keep this lease active. So what's happening is, in the market, today's market, the price of gas, you have to understand how that impacts you as a landowner. And a company landman is going to overblow that impact, and they're going to use that as a tool to get you to sign bad documents. Well, the reality is because of this situation and the economics out there, that you may have to sign documents that aren't going to be as good as what you would be presented if gas was $12 and $14 a unit instead of $1 to $2 a unit. So we need to, again, identify what type of leverage you have. So when you're looking at these minimum well obligations, and I'm going to make this up so we can have a nice, easy illustration. Say that your lease says that the company has to drill at least 1 well in 5 years, and then they have to have a total of 4 wells drilled in, we'll say, 8 years. So the bottom line is, in order to make this lease valid or to hold on to this lease, the company has to drill at least 1 well in 5 years. And again, making this simple, we're going to say it must drill another 3 wells within 8 years. Or, the company could drill all 4 wells in year 2 and they're okay. But they must have at least 1 well drilled by year 5 and at least 4 total wells by year 8. So what happens is across the board, I don't care if you take, look, I've dealt with this with Talisman, with Cabot, with Chesapeake, with Southwestern, any producer in northeastern Pennsylvania that inherits or has assigned these leases, and quite frankly, the same exact companies that entered into these leases with landowners that have minimum well obligations are often going back to the landowner and saying, hey, landowner, we would like you to amend or modify your lease so we do not have to drill this minimum number of wells, meaning we don't want to drill 4 wells within 8 years. Maybe what we're going to do, we've already drilled 1 or 2. We're required to drill 2 more within the next, say, 3 years. Would you give us some additional time in order to drill these additional 2 wells? Well, Every landowner is going to say, whoa, wait a second. That was a very important part of my lease. I wanted to get 4 wells in the ground drilled within 8 years, because how do I get royalties from production? So if I have 1 well producing or 4 wells producing, you're going to have 4, well, and it's not exactly, but say, little ballpark, say about 4 times more production. Again, please understand that's just as a generalization. But the bottom line is, what do you want to get royalties on? 1 well or 4 wells? 4 wells is going to give you more royalty than 1 well, and potentially significantly more royalty. So that was the purpose when landowners negotiated. They didn't want a company to do the old one and done, drill the well, pick up, leave town, and who knows, maybe we'll see you in 30, 40, 50 years whenever that well is drying up and you want to come drill another well. Well, a smart, strong defense to that was, hey, we don't want that to occur. One and done. We're only getting royalties from 1 well. And you're holding our property and holding our property. We want you to drill at least 4 wells, we'll say, within 8 years. So now the company says, geez, $5 to $7 million to drill these wells. Gas is being sold at $1 per unit, sometimes lower, $1, $2. Maybe we're getting up to $3 at times, but very, very low prices. We don't have the pipeline infrastructure to get this out to obtain higher prices. So what are we going to do? We're going to negotiate with the landowner, say, hey, landowner, will you extend this time so we don't have to drill these wells in the next couple years? We don't want to have to drill 2 more wells in the next 3 years. Okay, cool. Landowner says, well, what do you want? Do you want to just say, hey, you can drill these whenever? You can wait 50 years, 20 years, 10 years? Do you want to say, instead of drilling 2 more wells within the next 3 years, do you want to say, hey, will you give us 5 years? Will you give us 8 years to drill these 2 more wells? And those are all points of potential negotiation. With any lease amendment and modification, you must, as a landowner, understand your initial lease, or at least the most critical points of the initial lease that the company is seeking to amend and modify. So you must understand that. You must know, what do I have today? Then you must understand, what does the company want to do to modify, and what are they asking? So if I were to agree to this, I have my initial lease, I now have an amendment and modification. What exactly did I change? What did I give up? What was my benefit? Earlier I said, for that landowner who did a wrong assessment, who did a bad assessment of their leverage and said, well, the company doesn't want to offer me anything. They want to extend my unit size to make it, instead of a maximum of 640, they want to go to 1,200 acres in a unit. Well, I'm not going to do it. Well, that landowner said, I have leverage. They thought they had leverage. But the reality was, the company said, well, if you're not going to do it, we're going to let your lease die. We're either going to surrender it or we'll let it terminate. And your lease that you have now, we'll use in this example, has an 18% royalty. And I'll tell you what, landowner, you're not going to get 18% royalty again anytime soon, maybe ever. Who knows? But your offer, if you don't take this old lease expires. Your new offer may be $0 per acre, and it may be 12.5. Maybe it's 15% royalties. Maybe it allows deductions where your other one didn't. Critical that you understand your specific situation. So in that case, the landowner said, well, you're not offering me anything. I'm not going to give you something. Well, as twisted as it is, kind of the offer by the company in that scenario is, our offer is, we won't terminate. We won't surrender. We won't allow your original lease to terminate so you can get 18% royalty. But in exchange, we want to get larger unit sizes. And when you look at this whole picture, you may say, boy, this really stinks. I don't like this. I don't like this at all. I negotiated for certain things, but I'm in a bad spot. So what do we do? Anytime you're in a bad spot, anytime you're in a good spot, anytime you're in a medium spot, what do you want to do? Make the best of your situation. Understand your options, understand the positives and the negatives, and make the best of your specific situation. And generally speaking, that's going to take some insight from somebody who has dealt with this before, who understands all of these issues, that can assist you. Now, again, I'm not trying to make this a commercial, but it's the reality of it. It really is the reality of it. I've dealt with these lease amendments and modifications, and I'll tell you, sometimes they are extremely complex. Sometimes it takes me, especially at the beginning, hours. And somebody who looks at this all the time to really get to the bottom of what they're doing. Now, over time, it's much easier. Also, many of these aren't that hard, but some of them are very complicated. So we got to make sure that we understand, what do you have? What are they asking? I'm going to get back after this break, and I'm going to start, I think this next time, I'm going to kind of go down my list here. I think it'll be interesting. It's going to be a lot of stuff, but it'll give you an idea, because there is a lot of stuff to think about, a lot of stuff to consider. I am Attorney Doug Clark. You're listening to All Things Marcellus here every Sunday from 8 to 9 a.m., and I'm going to be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm, talking about oil and gas lease amendments and modifications, and talking about what I call these super leases, such as Friendsville, Wyoming County Landowner Group leases. We have Auburn. There's all these different groups out there that many of these leases, several of these leases have requirements that the gas company has to drill a certain number of wells, so a minimum number of wells within a certain designated time period. And what you're having is, with these gas prices, companies do not want to come in, expend the capital of drilling these wells at $5 to $7 million a well whenever they're going to sell the gas, assuming they have enough pipeline capacity to get the gas out, and they don't want to sell the gas at this $1 a unit to $2 a unit price. So a lot of times what you're seeing is landowners being approached to extend the time frame in which the company has to drill this minimum number of wells. So I've been using the example, say the company's required to drill 2 more wells under the terms of the oil and gas lease within the next 3 years. Company doesn't want to do that. So they say, hey, landowner, we would like some more time to drill these wells. Well, one thing as a landowner you're going to typically want to do is minimize that time. You don't want to give them 20 years. You want to give them, 2, 3, 4, 5, the lowest possible number. Also, you certainly want to look at what's in it for me. A one-time financial compensation payment, whether it's a certain number per acre, whether you're getting an increase in royalty percentage, which is unlikely, but you want to look at that. But remember, you can, and you don't want to. You don't want to overestimate your leverage. You don't want to assess your leverage and be wrong and think that you have all this power, because you don't want to be in a situation, especially if you have one of these big, strong leases, where that lease expires in total, and the next lease that you may or may not be offered is going to be it's not going to be near as good. It's not going to be as much money, not going to be the same royalty percentage. You're going to see probably deductions. So you got to be careful. You have to understand, what if I don't do this? You have to understand that. Then you must also understand that, okay, well, if maybe my entire lease won't be excluded, meaning it won't terminate, but say you have 100 acres and maybe only 25 acres are in a unit. Well, is there a chance, if you don't agree to this, that the other 75 acres could be released or surrendered? So you would have 25 acres under one of these big, strong group leases, but your 75 that you didn't agree to amend or modify, what if that ends up getting released or surrendered, and now you're looking for a new agreement, a new gas lease, but it's not going to be near the same amount of money and a lower royalty percentage? That could cost you hundreds and hundreds of thousands of dollars. You got to be careful. So and I can't stress this enough. I can't give any specific, and I never do, can't give specific legal advice on the radio show. I can't do it. And we need to look at everybody's unique personal situation. because maybe all of your property is in a unit and you're considering this amendment and modification. Maybe there's a well that's drilled under your property and you may have very strong leverage and you need to understand what that is and what may happen if you say yes or no. Maybe you have 100 acres and only 5 is in a unit. There's no well drilled under you, and everybody else has agreed to this amendment modification around you, and you have a lot of danger in that scenario of the company just releasing or surrendering your lease or 95 of your 100 acres, and now you're in a real bad spot. And that's because you did not evaluate this properly. You have to understand your individual situation. So I said, I was doing some lists, and I covered some of these, so I'm not going to go through them all, but this is just some ideas of what landowners need to be thinking about. Remember, we're just one small example saying that the company wants to extend the time to drill additional wells. So the question is, well, how many wells have they drilled now? How many additional wells are they required to drill? Are you receiving any shut-in payments? So if they drill a well and shut it in, how much money are you going to receive for that? As part of this negotiation process, maybe you do give them some more time to drill these wells, but maybe you get money up front. How much money? Maybe unlikely you get royalty percentage increase. How much? Maybe you can build in stronger shut-in protection. Maybe now if they shut in a well, they'll give you $5, but or per year, per acre. Maybe you can negotiate $100, $200 for shut-in payments. You got to look at all of these things in your specific case. How long do they want to extend the time to drill these additional wells? 2 years, 3 years, 5 years, 10 years. Can you negotiate that? You got to look at that. Are they asking also? Maybe they're required to drill 4 wells in, say, 8 or 10 years now. Are they asking now to only have to drill 3 wells or 2 wells? What exactly are they amending and modifying? Remember, we need to understand your original lease, and we need to understand the overall impact of any amendment and modification. So you must look at how many acres you own. Well, if you have 100 acres or you have 10 acres, your evaluation process may be different. Also, what is your personal life, income, money situation? Maybe you're more inclined to take some risks here. Maybe you're less inclined. How old are you as the landowner? If the company is offering you a one-time payment and that payment's fairly substantial and you're saying, well, geez, I'm 75 years old, I'm 70 years old, or maybe I'm on the verge of retirement, this will be a great payment for me. And yeah, it will extend the time for the company to produce royalties, but it'll put a nice lump sum into my pocket today, where I may be waiting for a long time to make up that money over time. Plus, I'm getting a lump sum in my pocket today, and I'm not giving up that much. I'm only giving the company 2, 3, 4 more years to drill that same number of wells. Look at, are there wells producing now? Maybe you have 2 wells producing now. Maybe you have 2 wells producing now, and due to the price of gas, you're saying, wow, my royalty checks are really low. Do I want to require a gas company to drill 2 more wells right away, immediately, and then sell this gas at a low price? Or do I want to say, hey, you know what? They're offering me some money right now I can put in my pocket, delay this production a few years, and hopefully then by the time that they start producing, gas prices will be higher, and this gas, I'd rather it be sold in 2, 3, 4, 5 years at a higher gas price than what they're obtaining today. Now listen, again, not specific advice for anyone. Do you think gas prices are going to go up? Do you not think gas prices are going to go up? How do you know? Are they going to go up or not? Do you really know? How much of that is a factor for you? All of those things come into play. If you're already receiving, thousands and thousands of dollars a month in royalty, and they want to extend a portion of your property or extend a lease as to a portion of your property, maybe you're willing to do that because you're going to get a nice, Potentially you're going to get a lump sum payment now, and you're already have a steady income stream coming in from other royalties that you say, hey, I don't mind extending this. Or maybe you're in a position where you're saying, hey, look, I want to get this royalties as much as possible, as soon as possible. I want these companies to drill these wells. And so I don't want to extend this. But you got to watch out. What could happen negatively? Could the company surrender, release my lease? Is that a possibility? What happens if, they go ahead, and this is what a company will say often, well, we'll drill these wells, but then we're just going to shut them in. So we can shut these wells in for 3 years, maybe 5 years, maybe longer, depending on your lease. And again, you got to understand your lease. Well, maybe they can shut these wells in, so you missed the opportunity for an upfront payment, and you thought you were making a good decision. You said no to the extension. The company goes ahead, they meet the requirements of your lease, and they drill, say, 2 more wells, but they shut them in for 3 years, 5 years. Well, in that scenario, maybe you would have been better, and probably, to take some money now to sign the extension and let the wells be drilled in 3 years, 2 years. You have to look at the complete picture. I am Attorney Doug Clark. You're listening to All Things Marcellus. I'm here every Sunday from 8 to 9 a.m. on these stations, and you can check out today's show and any other show. Well, not any other show. Recent shows, we'll say. Recent shows. PA Gas Lease Attorney.com, PipelineAttorney.com. So again, just some other ideas, some other things that you need to be considering whenever you're looking at this. How many other leases in your unit need to be modified? Are you the only person? Does that give you extra leverage? Does that give you lower leverage? You got to look at that, because that can cut both ways too. You have to understand that aspect. Are there 15 people out of 20 that need to sign and 10 of them aren't going to sign? Well, then do you want to keep pursuing this? You got to look at that as well. You, of course, want to look at also, if you are, how much money are you being offered? What are you being offered? What can you negotiate to decrease, minimize, or eliminate as much as the negative consequences to you as the landowner in signing an amendment and modification? I can tell you this. I've seen cases where landowners signed amendments and modifications, and in my opinion, clearly they never should have. I've seen other cases where landowners did not sign amendments and modifications, and they really, really hurt themselves. Cost themselves tens of thousands, hundreds of thousands, and potentially millions of dollars. So you have to fully understand this. And who are you going to rely on? Are you going to rely on the gas company landman who works for the company? Are you going to rely on your own experiences? Yeah, you're absolutely entitled to do that. I would strongly suggest that you make sure that you speak with somebody, and you'll hear me talk, even a consultation and review, to understand your rights. And sometimes we have these conversations, and so this is great because it supports my thought. Or, wow, I wasn't thinking about things that way. And again, this radio show, we want you to think about things that maybe you didn't think about before. I can't stress enough. These are individual decisions for individuals, not group decisions for groups. Everybody is in a different financial life situation. You must understand your situation. You may have a well underneath you, somebody else doesn't. Everything else could be identical, and that could be a game changer. So many, many things to think about. Please keep thinking. I am Attorney Doug Clark. You're listening to All Things Marcellus. I'm up against it here every Sunday from 8 to 9 a.m., and I'll be back next week. Have a great week, everyone.